ਕਾਰੋਬਾਰ ਸੰਬੰਧੀ ਇਸ਼ਤਿਹਾਰ ਲਗਵਾਉਣ ਲਈ ਸੰਪਰਕ ਕਰੋ ਸਾਡੇ ਨੰਬਰ 2013124180 ਜਾਂ ਸਾਡੀ ਈਮੇਲ ਆਈਡੀ preetnamausa@gmail.com।
Good morning, everyone. Sat Sri Akal, Assalamu alaikum, Namaskar, everybody. Welcome in Preetnama Manch. Once again, we are here without informing today. I hope you all are well. We are really sorry because we not informed to everyone what we're doing today. So today we came here. मैं हिंदी में ही बात करूंगी और इंग्लिश में भी आपको दोनों में, क्योंकि हम आज का जो हमारा शो है वो इमिग्रेशन के बारे में है। आई नो दिस टाइम इज रनिंग सीरियसली लिटिल स्ट्रेसफुल, एवरीबॉडी नोज, सो everybody need help. They have a lot of question about the immigration cases, visa process, kind of spouse visas, virus visas, a lot of question everyone have. So we try to help everywhere, we are doing the all kind of show as you guys know. So अब आज से हम लोग स्टार्ट करने जा रहे हैं इमिग्रेशन हेल्प। इमिग्रेशन हेल्प के 4 शो कंटिन्यू होंगे। आज फर्स्ट शो है हमारे साथ, जो ये फुल मंथ है, गेही लॉ फर्म। एवरीवन वेरी वेल नो देम, गेही, मिस्टर नरेश गेही, असाइलम किंग के नाम से भी लोग जानते हैं। असाइलम केसेस के किंग माने जाते हैं। दैट्स अ वेरी इज वेरी एक्सपीरियंस्ड एंड वेरी नाइस ऑसम सोल एंड हेल्प टू एवरीवन। एंड उनके 2 अटर्नी हमारे साथ हैं, मिस्टर मिकान जैंग, कनिका चौधरी। they will give the question and answer. I will ask the question, they will answer you. And but next show, you guys can ask the question by email, by text message, or you can go by live to ask, and they will must reply to you. But today we asking the some question जो आप लोगों को जानने होते हैं। हमें पता है कि जरूरी है, आपके मन में, सबके मन में होते हैं कि ये ऐसे ऐसे, और उनको होता है कि हाँ इतनी फीस लगेगी, अटर्नी के पास जाएंगे, पूछेंगे तो वो चार्जेस करेंगे। नहीं, प्रीतनामा हेल्प यू ऑलवेज ऑल काइंड ऑफ प्रॉब्लम्स। सो आज अभी फुल मंथ हम आपका इमिग्रेशन हेल्प का लेके आए हैं। तो आपको कोई भी क्वेश्चन हो, मैं स्टार्टिंग में बता देती हूँ, आप लाइव में पूछ सकते हैं, आप वाया ईमेल पहले से पूछ सकते हैं कि अगले शो में मैम हमें इसका आंसर चाहिए, और आप वाया टेक्स्ट मैसेज, व्हाट्सएप, एनी आप क्वेश्चन भेज दें या लाइव में पूछे, आपको किसी भी क्वेश्चन का आंसर चाहिए। सो वी आर गोइंग टू स्टार्ट। वेलकम मिस कनिका चौधरी एंड Mr. Jang and Preetnama Manch, and we are very excited to hear you because I have a lot of questions too. So if I know the question, I can reply to my viewers, right? So welcome, Kanika Chaudhary. Can you give your introduction, yourself, and your firm introductions, please?
Yes. Thank you, Preet, for welcoming us. It's been a pleasure to be on your show. Today, I am representing Gehi Associates. I'm senior law clerk in Gehi Associates, and I have been working with this firm for approximately 3 years now. And we have been dealing with all kind of laws. We deal with immigration, personal injury, we deal with family law, all. But our main part is immigration law. सो हमारे जितने भी लोग हैं जो हमसे कनेक्ट होते हैं, वो इंडियन सोसाइटी, बहुत सारी कंट्रीज के लोग हैं, बट सबसे ज़्यादा हम लोग अभी प्रेजेंटली इमिग्रेशन पे फोकस कर रहे हैं। हमारे सारे केसेस मोस्टली इमिग्रेशन के हैं। हम लोग जितने भी लोगों को हेल्प कर रहे हैं, जितने भी लोग हमारे पास कंसल्टेशन के लिए आते हैं, हम उन्हें फ्री कंसल्टेशन प्रोवाइड करते हैं। हमारे ऑफिस के 3 ब्रांचेस हैं, ओजोन पार्क, जमैका एंड जैक्सन हाइट्स, और एक ब्रांच टेक्सास में है। हम सबको हेल्प करते हैं, फ्री कंसल्टेशन देते हैं, एंड वहाँ से वी डिसाइड व्हाट स्ट्रैटेजी टू टेक, एंड देन वी हेल्प देम टू स्टार्ट देयर केस। सो we are very happy to be on your show.
Thank you so much, Kanika. Mr. Jan, can you introduce yourself too?
Yes, thank you, host. My name is Ming Kwan Zeng, and I am one of the attorneys work at Gehi Associates, and my expertise is specialized in immigration law practice. Insofar, especially with Gehi and Associates, I have had the honor to have clients from all around the world, from India, from Latin American countries, Guyana, Africa, etc. And I'm so happy to join today's immigration talk show because I'm so exciting to share my insight as to the current immigration trend. Thank you.
Thank you so much, Mr. Chang. So let's go. We are getting late. And I have some question because we are doing this. I was so busy. I didn't get enough time to tell my viewers what we are doing today. So, but I have some questions. So I'm gonna be asked one by one. So you guys just raise your hand who gonna answer first. So the first question I want to about finance visa because everybody know the finance visa. These days, especially last month, was like everybody we had the finance visa for USA. So I want to ask about the K1 visa, finance visa. What document are required for finance visa application and who gonna be replying? Kanika? Yes, please.
Okay, so basically, K1 visa is a fiancé visa. If you are engaged to someone who is overseas and after engagement you want to bring them to United States, then you can apply for them. You can apply for their paperwork so that they can be here. You guys can get married, and ultimately, she or he can become a U.S. citizen. So
Sorry to interrupt you, Kanika. Can you reply in Hindi this question because I know
yes,
a lot of people have like they
yes, yes.
understand
I
Hindi
was
very well.
about to say in Hindi now.
Yeah,
So
please.
फियांसे वीज़ा बेसिकली आपके जिनसे इंगेजमेंट हुई है जो यहाँ इस कंट्री में नहीं है, आपकी किसी और कंट्री में, आपकी होम कंट्री में आपकी इंगेजमेंट हुई है, आपको उन्हें यहाँ लेके आना है, आप यूएस सिटीजन हैं, तो आप उनके लिए अप्लाई कर सकते हैं, उसके लिए हम फियांसे वीज़ा अप्लाई करते हैं. The first thing, there are a lot of things that are required to prove that you are a US citizen. You need to show आपको अपना बर्थ सर्टिफिकेट, अपना यूएस पासपोर्ट या नेचुरलाइजेशन सर्टिफिकेट दिखाना पड़ता है. Then you have to prove your relationship, that this relationship is genuine. You have photographs of you guys together, you have communications, emails, logs, travel itineraries, pictures together, phone records. These things help to show कि आप लोगों का relationship है, आप लोग एक रिलेशनशिप में है और अब इसलिए ये एक जेन्युइन रिलेशन है कि आप उन्हें बुलाना चाहते हैं. फिर आपको ये दिखाना पड़ता है कि आपका इंटेंशन है कि जब वो यहाँ आएंगे तो आप उनसे शादी करेंगे. So you need to basically prove that you have statement of intent to marry. Then you need to get married to the person within 90 days of their arrival into United States. And then last thing is basically you need to show that you have enough legal capacity or enough, like you are basically eligible to get married. आप शादी कर सकते हैं लीगली. आपकी कोई शादी नहीं हो रखी पास्ट में जिसमें आपका डिवोर्स हो नहीं हुआ है और आप लीगली अलाउड नहीं है मैरी करना, तो वो एक बहुत बड़ा रीज़न होता है. क्योंकि बैक होम कुछ लोगों का कॉमन लॉ, जैसे गयाना में कॉमन लॉ, इंडिया में आर्य समाज वेडिंग एंड ऑल होते हैं, तो उन वेडिंग्स का लोगों को इतना इंफॉर्मेशन नहीं होता दैट दे आर नॉट डिवोर्स्ड बैक इन देयर कंट्री. So they start the process, but then later on, after due diligence, we find out that these people are married. So we have to first initiate the divorce process. पहले हम ये देखते हैं कि आप legally capable है शादी करने के. Now I will like Zhang to add a few things as he feel comfortable about this topic.
Yes.
Yes, thank you, Kanika. Oh, yes. So recently we had a very, very interesting case. Client came to us. Actually, she wanted to apply for the marriage-based green card for her husband. But later on, we find out, okay, so I think it's, I don't remember which country, but in that country, like there is process to get like a marriage license and then like to officially get married. So it's basically like two steps. But the client was not sure. Like she believed that okay, maybe one step is enough to establish and marry. But upon our research, because when we take case, we always do our due diligence research first. So we find out it's kind of you registered, but only for you to be eligible to get married. So client then decided, okay, maybe I will just go with a fiance visa. So after she knows that the pending time is about like 10 months, 11 months, and then the consulate processing time can be like 4 months. She feels, oh, it's really fits my current situation, because fiance visa, it is not just about like to get a visa, it's also mirroring one's relationship. So again, when client comes to me, I always ask them, okay, if the fiance visa fits your current relationship status, then I do believe now rushing to marriage is the correct decision.
Mm-hmm. Yeah, okay, so I think you very well explained, Ms. Kanka and Mr. Jang. Thank you so much. And
You're welcome, host.
I'm sorry, the fiancé visa, K1 visa, I put on finance visa before. I'm sorry. So what the better spouse, how long does it take? I mean, how long does it take to process? Is this a petition or better spouse?
Okay, so I will start and then Zhang will add on to
Yes,
it.
yes.
Okay, so
तो आप
basically,
हिंदी में हाँ बताएं कि कितना समय लगता है इसकी petition?
वावा इस बैटर्ड स्पाउस केस का लीगल नेम है वावा केस.
वावा
ओके,
केस.
वायलेंस अगेंस्ट वुमेन्स एक्ट.
हम्म.
इसके अंदर आप खुद को पेटिशन कर सकते हैं अगर आपने अपनी मैरिज में कोई भी अब्यूज, नॉट इवन जस्ट मैरिज, इवन इफ यू आर अब्यूज्ड बाय योर चिल्ड्रन और पेरेंट, एनीवन लाइक who is a US citizen, your immediate relative, you have been abused by them. आपको कोई भी अब्यूज हुआ है अपने फैमिली मेंबर से जो कि यहीं है और यूएस सिटीजन है, तो आप वावा का केस फाइल कर सकते हैं.
Uh,
आपको
just want to interrupt you. I'm sorry. I'm like bothering you again middle of the question. मैंने ये जैसा सुना है कि वावा के केस अभी और नहीं मतलब लग रहे हैं कि बंद हो गया ये, ऐसा हम कुछ नहीं कर सकते अब. Is that true?
नो
Because
ऑन रेगुलर
बहुत सारे
बेसिस
लोगों से मैंने सुना है कि जैसे ही ट्रम्प गवर्नमेंट आई है तो उसके बाद उन्होंने ये बंद कर दिया है.
उन्होंने मैम उन्होंने ये बंद नहीं किया है. दे हैव मेड इट मोर कॉम्प्लेक्स एंड बेसिकली दे हैव मेड द स्क्रूटनी हाई बिकॉज पहले वावा में इंटरव्यूज नहीं होते थे. पहले वावा में बहुत चीजें वेव होके वो अग्री करते थे सिर्फ एविडेंस के बेसिस पे कि यू क्वालिफाई फॉर दैट और नॉट. बट नाउ दे they will give you an interview. You have to appear in front of a USS officer, present them your case, like how you were abused, what are the proofs, what is the, like how you can basically demonstrate that you have been abused by your partner, threatened, or and then they will, there is a strict level of scrutiny now to grant wawa cases, but that is not true that there is no more wawa cases now. And also, the processing time for Wawa cases might vary from like 12 to 24 months. It might take time. It is a long time taking process, but the process is certain if you have genuinely faced, अगर आपने अपनी मैरिज में या अपने घर वालों के साथ कोई भी थ्रेट जेन्युइनली फेस किया और आपके पास इनफ प्रूफ्स है. जरूरी नहीं है कि वो सिर्फ फिजिकल अब्यूज हो. इट कैन बी मेंटल, इमोशनल abuse. So you have to prove that to USCIS. If you are able to prove and you have enough proofs, like you have police reports and everything to add on, then your case becomes strong, and then USCIS make decision. And Zhang will add on to this.
Yes.
Yes, so after you submit the Viva petition, the first decision USCIS will make if they don't issue request for evidence is a prima facie determination letter. So on that letter, basically, the USCIS will say, okay, your situation meets the VIVA criteria, but it does not mean your VIVA petition is approved, because we have clients who received the redetermination letter, and later on, USCIS issued another request for evidence, for example, demand for police report to see whether the client has other criminal records, and in addition to that, they may revisit the relationship. They may say, okay, the initial submission, you submitted marriage license and certificate, how to prove you were in that relationship. Because VIVA for me is, my view onto it is another version of asylum. So with client who has good track records here in the United States, their case has easier approval. For example, if the client is a financial expert and then has a VIVA case pending, usually those niche of client, their case got favorable discretionary findings. So again, VIVA is just not a brutal story about how you are abused, also how you live your life in the United States as a law-abiding resident. Thank you.
So thank you so much, Mr. Yang and Kanika. मुझे आई होप कि जितने भी व्यूअर्स देखेंगे बाद में, या देख रहे हैं जहाँ बाद में देखेंगे, उनको उनके आंसर मिल गए होंगे. नेक्स्ट क्वेश्चन मिस कनिका की, कैन समवन फेसिंग डेपुटेशन बी ग्रांटेड वॉलंटरी डिपार्चर?
Yes, my answer to it is yes. So basically, voluntary departure allows a person who is facing deportation या removal, जो face कर रहे हैं, वो removal order मिलने से पहले, hearing से पहले ये decision ले सकते हैं कि वो खुद इस country को छोड़ के जाना चाहते हैं. वो जज को ये इन्फॉर्म कर सकते हैं कि मुझे खुद वॉलंटरी डिपार्चर दे दो, आई वांट टू लीव दिस कंट्री, आई एम अ पर्सन ऑफ गुड मॉरल कैरेक्टर and I have not done any crime in this country, but I want to leave it on my own will. So in voluntary departure, you basically have to book your tickets yourself. Your expense of leaving this country will be borne by you. So, but for taking voluntary departure is beneficial because in future that might affect you from bans, like ban of 10-year or re-entering this country. The person who has been granted a voluntary departure, it is easier for that individual to return back to the country. Usually after like 150 or 160 days they can apply for a waiver, and then they will be able to return back to United States in future. So we strongly believe that voluntary departure is very much important, and also is very much required for someone जो ये सोचते हैं कि मैं इसका, मेरे को रिमूवल ऑर्डर मिल जाएगा तो मेरा क्या होगा, मेरे को 10 साल तक एंट्री नहीं मिलेगी. तो आप उससे पहले ये डिसीजन ले सकते हैं कि आप खुद छोड़ के चले जाएं, ताकि आपका टाइम जो आपका बैन है वो रिड्यूस हो जाए और आप वापस लीगली इस कंट्री में आ पाए. And Zhang will throw more light on this topic.
Yes, Mr. Chang, please.
Yes. Yeah, so voluntary departure for me, actually, at the beginning when I heard of it, I feel is very prejudicial in a sense, like a voluntary departure, which means with that order, you need to immediately move to the United States. Even, you are given like a 120-day grace period to plan your trip. But later on, I realized that actually a lot of clients, they are issued like a voluntary departure order, but they stay in the United States and then further work on their case and get their case reopened. So as long as it's like bona fide, it's like happen naturally, then like voluntary departure really give client the room to reconsider, okay, whether I want to plan my future here in the United States, or I just take the order, move back, and then apply another form of visa to re-enter the United States in the future, because sometimes I do believe like have a break from the United States and stay in the home country to see, okay, what happened in my home country, what my life can be in my home country is also beneficial for one's personal and career development. And at the same time, like the 120-day grace period is not automatic. For people who detained in ICE facility, when there are issues with the order, the ICE actually executes, the DHS executes the order. So they may monitor the client, go to the airport and then leave, because voluntary departure, another interpretation is I voluntarily can choose this date to leave. And then they, the DHS stance is like, okay, if your contract is I'm leaving on May 1st, then okay, we are sending you to the airport and say goodbye to the United States. And that's it. Thank you.
Thank you so much, Mr. Jang. So, Kanika, how long, I mean, the US visa is valid, और क्या हम लोग इसे permanent residency के तौर पे कर सकते हैं?
So, ma'am, basically, I think US visa is valid like till whatever time you get it, but I believe you are willing to ask about U visa, I guess.
Yeah, U visa.
Yes, yes. So U visa is basically valid for 4 years, and उसके बाद आप ग्रीन कार्ड के लिए अप्लाई कर सकते हैं. 3 years after you have your visa, you become eligible for a green card. So you can apply for adjustment of status. But in U visa, you have to prove that कि आपका continuous residence है इस country में. आप continuously यहाँ पे आपका physical presence है. आप 3 साल at least before applying for a green card, you have to show that you have maintained your U visa status. You have been providing like you have helped the enforcement agency to find out about that particular crime of which you were victim of. So U visa basically is for a victim of a particular crime who have witnessed a crime and they have been affected by that crime. So they are granted U visa because they help वो लॉ इन्फोर्समेंट एजेंसीज या पुलिस को हेल्प करते हैं ये पता लगाने में कि उस टाइम पे उस इंसिडेंट में क्या हुआ था उस बेसिस पे आपको यू वीजा मिलता है and yes it is valid and you can also provide if you are getting u visa your children can be added as a derivative status to that visa so अगर फादर के साथ कुछ हुआ है या मदर के साथ कुछ हुआ है तो आपके बच्चे भी एज अ डेरिवेटिव इस वीजा में ऐड हो सकते हैं एंड उनको भी आपके थ्रू ग्रीन कार्ड मिल सकता है अगर वो बच्चे माइनर है तो okay
Got you.
and Zhang will talk more about it.
Yes, Mr. Jang, about the
Yes.
visa.
Yes, so for U visa actually is like three parties. One is the client, one is actually the people which the police department will contact the prosecutor and bring the case to the court. And then another party is USCIS. So it is very essential for our client to know it's not just if you are a victim, you can apply for that visa. It has to be you work with the police and then the police acknowledge there is a case pending and you are the victim and the evidence on their hand enough to bring charges, and then the case can potentially pending for example, a few years. And then that gives you the visa, and then once you maintain that status, then it's a pathway to green card or eventually citizenship. Thank you.
Thank you so much. The next most important question I want to ask you about the marriage and immigrations. That what is the difference between conditional green card and a permanent green card after the marriage? कि दोनों में क्या difference है?
So if you have been married to a US citizen or a green card holder and they are applying for your paperwork, they are अगर आपकी शादी हुई है किसी ग्रीन कार्ड होल्डर के साथ या यूएस सिटीजन के साथ और वो आपके लिए परमानेंट रेजिडेंसी के लिए अप्लाई कर रहे हैं तो अगर आपकी शादी को लेस देन 2 इयर्स हुआ है और ये प्रोसेस स्टार्ट हो गया है, मोस्टली उन सिचुएशन में आपको आपको एक कंडीशनल ग्रीन कार्ड मिलता है जो कि 2 इयर्स तक वैलिड होता है. And after reaching 1.5 year, when you are like 6 months before reaching 2 years, you can apply for a permanent green card. And in that permanent green card is granted for 10 years. So that permanent green card basically, um, when you are applying for that permanent green card, you need to show that the marriage is still bona fide, you are still married happily, you are still living together. Because बहुत सारे लोग कंडीशनल ग्रीन कार्ड के बाद कुछ ऐसा हो जाता है उनके मैरिज में कि उनके मैरिज में प्रॉब्लम्स आ जाएं, तो लोगों के माइंड में ये मिथ है कि हमें फिर 10 ईयर वाला ग्रीन कार्ड नहीं मिल सकता है. ये ऐसा नहीं है. अगर आपको 2 साल के बाद जब आप अप्लाई कर रहे हैं 10 ईयर एंड आपको कोई भी इशू आता है, तो भी कंडीशन और चीजें पॉसिबल है जिससे कि आपको अपना 10 ईयर ग्रीन कार्ड मिल जाएगा. वी कैन अप्लाई विद अ वेवर फ्रॉम जॉइंट फाइलिंग. In that case, if even if the other party is not with you right now, you have been separated or divorced for, like, you are not staying together, but when you entered into the marriage, this marriage was real for love, it was bona fide marriage, then we can apply for the waiver, and then also you will be eligible for a 10-year green card. I think it will be better and much more understandable if Zhang throw a little bit more light on this.
Yes, please, Mr. Jang.
Yes, thank you. So again, like the application 751 for me is kind of very tricky in a sense. A lot of clients like enter marriage with good faith. However, later on the marriage did not work. So they have the option to file their green card like alone. Another interesting case we recently had is actually the client remained in marriage to a U.S. citizen for 3 years and will apply for the leave condition on green card, and it is still pending. And yes, their marriage has some issue, but actually client applied the citizenship since like he missed the 3 year requirement. We helped client file the application and there was an interview conducted. And the officer, I still remember when we show up in the office, the officer say, okay, if it's based on US spouse, then like the US spouse for citizenship has to show up. But it's not the case, but the US CIS officer can truly require that. So also client has VIVA pending. So the officers kind of sense like, okay, what happened to the client? So what he does is actually, he said, I will look at the 751 petition first. I will look at the evidence in relation to your VIVA case. And then after we close two cases, we make final determination on your citizenship application. So again, like that case made me realize actually USCI officer, they are actually help client with their cases. Not just, for example, okay, if you meet the requirement, I approve it, it has to be strictly met, otherwise I would deny it. No, it's not the case. Like we work along with the client and the USCIS to get the client the best result. Thank you.
Thank you so much, Mr. Jang. You guys explained very well. मुझे उम्मीद है कि आपने सबको समझ आ गया. So I want to say to thank you to my viewer who are watching. So everybody, Dr. Ashwini, the names are going up. So whoever in front of me, Iqbalji, everybody, thank you so much. It's a very like informative programs must share with everyone. So I know that everyone have the question, so they not ask they just scared to go to the lawyer about the some reasons, some of the fees. So please must share this program. The next question I just want to about appeal, filing and filing an appeal before immigration court. According that, what happens if BIA dismiss your appeal? I mean, if for somebody file the appeal and the BIA just dismiss, तो क्या होगा उसके बाद फिर, Miss Kanika?
On this particular question, I will speak little and I will like Zhang to speak more. Because
but
इन बीआईए
Hindi.
केसेस इन बीआईए केसेस जब भी आपकी अपील अगर डिनाई हो जाए या डिसमिस हो जाए, तो यूजुअली आपको एक टाइम 30 days दिए जाते हैं, आप इस कंट्री को छोड़ के जा सकते हैं. यू हैव टू डिपार्ट फ्रॉम यूएस एज ऑर्डर्ड. So
Mhm.
you should depart within the timeline, or if you don't want to depart, we can file a petition for review to US Circuit Court of Appeals. Like it, BIA is not just the last step. इसके बाद भी अपील हो सकता है. हम पेटिशन फॉर रिव्यू फाइल कर सकते हैं सर्किट कोर्ट अपील्स में. दैट हैज टू बी डन विद इन 30 days ऑफ द डिसीजन मेड बाय द बोर्ड ऑफ इमिग्रेशन जज. And then filing this appeal with federal court, like there are multiple things that needs to be taken into consideration. बहुत चीजें ध्यान रखनी पड़ती है जब आप एक फेडरल लॉसूट फाइल कर रहे हैं. बेसिकली यू आर फाइलिंग विद द फेडरल कोर्ट. दैट इन्वॉल्व्स लाइक कॉम्प्लेक्स लीगल आर्ग्यूमेंट्स हमारे अटॉर्नीज फ्रेम करते हैं. Strict deadlines have to be followed because these cases you cannot even take a chance for one day. It is a serious appeal, so everything has to be accounted for. We have great team of attorneys who help you with filing these circuit court cases, but I will like Zhang to speak more on this topic.
Yes, Mr.
Yes, yes, thank you. So for the federal case, actually, I have witnessed few, and I personally actually taken care of a court of appeal case, next circuit, from beginning to the end. And that case made me realize the BIA, the immigration court, and the federal court, they actually work aligned with each other. For example, I feel attorney's duty is basically check and balance what happened during the BIA process. If there is truly like a controversy to be resolved, then the federal court of appeal will give its determination. For example, if it is based on mistakenly apply the law, then like our function is get the case reversed to the BIA, and then BIA judge redetermine the case and reapply the correct law. And again, like unfortunately, that case I lost, but at the same time, like I just feel okay, since like there's no way to go. How about I just refile with the immigration court? And when I refile immigration court, a motion to reopen is granted. So that gives client like status in the United States and the option to apply for work permit. And again, like court of appeal is very strict about like when they reverse the case, because it's not just only about the law, it's also about the judge. When the judge receive like the reversal decision, they may feel like disappointed about themselves as well. So when we do the appeal, we actually like very carefully like draft our briefs. So we don't want to say, okay, the judge absolutely not correct unless there is some legal or procedure error in the case. Thank you.
Thank you so much, Mr. Jang and Ms. Kanika. You guys explained very well. So the next question, I just want to ask about the special immigrant, my SIG. Can a special immigration SIG applicant adjust their status to green card or no?
Yes. So once a minor has been classified or has been granted a SIG classification, जब कोई minor जिनको अपने parent से कोई neglect, basically neglect इसका main term है, if they have been neglected by their parent in their country, or if maybe if the parent is here, and it is not necessary कि दोनों parent ने उन्हें neglect किया है, either of the parent, then the other parent can become the legal guardian for their child, or any third party, any family member can become a guardian for that child, and then they can apply for the guardianship or in the family court. Once the order is granted, they have the special finding orders, we can move ahead and file with USCIS, and they have to make sure इस पूरे केस में that this child and guardian both are physically present in United States. They cannot leave the country while this process is going on. They have both have to be here, and once the immigrant visa is available under EB4
तो
category.
सॉरी टू मैं अभी पूछना चाहती हूँ बीच में इसी लाइन पे कि आपने जैसे कहा कि पेरेंट्स ने उनको नेगलेक्ट किया है, लेकिन कोई और उनका गार्डियन जैसे उनके पेरेंट्स में से ग्रैंडफादर ग्रैंडमदर उनको कर रहे हैं एज ए वो उनके तो लेकिन तब भी उनके पेरेंट्स को यहाँ पे रहना पड़ेगा, उनका तब भी रोल है इस बीच में?
नहीं मैम, नहीं। पेरेंट्स का जो पार्टी है जिन्होंने नेग्लेक्ट किया है उनका इस पूरे केस में कोई रोल नहीं है एक्सेप्ट दे हैव टू साइन द वेवर.
नो.
But only the child and the guardian has to be here. Only the child and the guardian has to be in United States. Parent can be anywhere because we have a lot of cases where people like from their home country, अपनी country से उनको किसी भी एक parent ने neglect किया, maybe उनकी वापस शादी हो गई, उन्होंने उस child को enough financial like enough finances provide नहीं करे, child हमेशा neglected right in terms of anything. It can be in terms of love, in terms of money, in terms of respect, anything. And the other parent or a third person in the family wants to be the legal guardian for the child, to provide for the child and help the child in obtaining status in United States.
And one more question, please. कि I know parents में family में grandfather grandmother आ गए, इसके अलावा और कौन कर सकता है? I mean, out of family can do or no? Like somebody I know, so when the kids are like neglected by their parents, I want to be a guardian, and I can do something. I mean, out of the family member, out of the family, anyone can do for him.
Yes, yes, anyone can do, but they have to be a close family relative. Like they have to prove that they are related to their family. It's not like completely unrelated party and they become the guardian for the child, because that they have to show that the child is staying with them, they are providing for them, so they have to be related party. They have to show at least some connection to the person. But yes, definitely Zain can tell more about it.
Yeah, please.
Yes, yes. So for special juvenile visa status, what essential is to have the state family court judge sign the order and recognize the custody or guardianship over the child. And at the same time, the state judge will view the factual information, whether only one parent or like no parent at all, like with the kid, the minor applicant. And what is most important thing for client to know is where the children lives, because some states, for example Virginia, like you can start a case and finish before the child turn 21 to petition for the child, but you have to start the case with the family court before the child turns 18. There are special circumstances we can apply, but again, like my practice is a little bit conservative in a sense. When the state court like to establish jurisdiction is under 18, I really don't push that far, because for example, a client has alternative relief such as, for example, asylum, even student visa. So we take case just not like focus on one petition. We always see which path we should go. Maybe we submit multiple application and then to see which one we can get the best result.
Thank you so much. Thank you, Mr. Jain.
Yes.
So I'm gonna again repeat कि आप लोगों को कोई भी क्वेश्चन है प्लीज तो आप लोग पूछ सकते हैं, लाइव में पूछ सकते हैं और वाया ईमेल वाया टेक्स्ट मैसेज पूछ सकते हैं. मिस्टर नरेश गेही, उनकी फुल फॉर्म के जितने भी अटर्नी हैं आपकी फ्री ऑफ कॉस्ट आपको सजेशन एडवाइस देंगे. दे आर वेरी वेरी एक्सपीरियंस, दे ऑल आर, एंड यू गाइस आर watching this show and you will जब people बाद में भी आप लोग वॉच करोगे इस शो को, तो मैं आपको बता देती हूँ कि दे आर रियली एक्सपीरियंस, बहुत ही तजर्बेकार अटर्नी है सारे, और दे हेल्प like a family, not like you guys can go, they have the location, we will share the location again. And now let's go to the next question. I'm going to talk about the TPS. Can someone on TPS, means temporary protected status, they can apply for the work permit or no?
Yes, they can apply for the work permit, that's true. But now, TPS standard has been stricter. So, not every person is eligible for TPS. There
Mhm.
are very certain designated countries. कुछ countries ही है जहाँ के लोग को अब TPS allowed है. And to be in a TPS status, you have to keep renewing your TPS status. You cannot just apply once and then leave it and then have a work permit based on if you keep applying your TPS. Basically, when you renew your TPS or you apply for TPS at the same time, उसी टाइम पे आप अपना वर्क ऑथराइजेशन एप्लीकेशन भी फाइल कर सकते हैं. टीपीएस आपको एक टेम्पररी प्रोटेक्टेड स्टे देता है इस कंट्री में, जो कि एक टेम्पररी पीरियड ऑफ टाइम के लिए होता है कि आप अपनी कंट्री में अभी वापस नहीं जा सकते बिकॉज ऑफ व्हाट्स एवर रीजन इट कैन बी. बट यू हैव टू, if you are applying for TPS, you are eligible for work permit, but you have to keep the TPS renew holders have to keep renewing both the TPS and the work permit. It is not permanent. It has to be renewed after the expired period of time.
Okay, thank you.
And
Mhm.
yes, yes, I
Next.
hope it answers your question. So we can move to the next question.
Okay, good. Thank you so much. And the next question I'm gonna ask about your deputation and relief from removal. What are some uncommon forms of relief from deputations?
Okay, so according to my knowledge, I would say the first would be we can definitely apply for an asylum if a person is threatened back in their country based on their race, caste, religion, political opinion, anything that qualifies them to apply for asylum in United States. They
Mhm.
can apply for asylum, and that can help them to prevent them from removal. So अगर आपको अपनी कंट्री में कोई थ्रेट है कुछ भी, तो आप असाइलम अप्लाई कर सकते हैं. अगर आप इस कंट्री में 10 साल से ज्यादा यहाँ रह चुके हैं और आपका एक क्लियर रिकॉर्ड है, आपने टैक्सेस फाइल किए हैं, आपके बच्चे हैं यूएस born, or if there is any situation like that can tell US government that you have been a person of good moral character,
Mhm.
then you can even apply for cancellation of removal. And we have a very experienced team who specifically works on cancellation of removal cases, because these cases require a strong memo, a legal brief, because some people believe that after obtaining this knowledge in the free consultation, they might be able to do it on their own. But that's not the truth. If you don't have an immigration attorney who's overseeing your work or who's overseeing how the facts have to be presented, आप
Mhm.
खुद फाइल करके गलती कर सकते हैं. तो इसलिए आपको एक इमिग्रेशन अटर्नी आपकी फाइल पे होना बहुत ज़रूरी है, सो दैट दे सी एवरीथिंग इज बीइंग filed properly with all the documentation, because in court filing you cannot keep filing things. Whatever you file is on the court portal forever. That cannot be deleted. So you have to be very careful before you file.
तो यहाँ पे कनिका मैं आपसे दो क्वेश्चन पूछना चाहूंगी. एक तो ये कि मेरी नॉलेज में किसी ने पूछा था एक क्वेश्चन कि कोई बंदा यहाँ पे मान लीजिए 10 साल से रह रहा है, लेकिन वो टूरिस्ट वीजे पे आया था और उसके बाद वो गया ही नहीं, लेकिन वो टैक्स फाइल भी कर रहा है, काम कर रहा है, सब कुछ कर रहा है. आई मीन काम वो कर रहा है, लीगल नहीं कर रहा है लेकिन कर रहा है और टैक्स फाइल कर रहा है. सो दे कैन अप्लाई फॉर.
Nahi, ma'am, because they have to be in removal proceeding to apply for cancellation of removal. If this person is not in removal, if this person has like his entry, he has just overstayed his visa and nothing has been filed for him, so he is not in removal proceeding. He can apply for adjustment of status if he has a immediate relative, or if not, he can apply for waiver to for his extended period of stay, for his unlawful presence, and then he can apply for adjustment, but not directly. He is not qualified for cancellation of removal.
Got you. Thank you. So one more question came to me for after this show. Somebody was watching and he sent the question. Like he said he was here 2 times before. Like वो जब आया 2-3 बार आया तो तीसरी बार जब आया तो he didn't went back because उसको कुछ problem था उसकी country में. He not related to India, he's somewhere else, but he had the problem in like some issues with the religious side.
Okay.
But he filed the asylum and work permit himself. He still have valid work permit, but it's a long time now, like around 5 years. He didn't get any interview. He didn't get anything, but he did. Uh, he do his work permit renewal himself too, and he's getting to. But he don't get any interview, anything from the others.
Yeah, so sometimes, like when you enter legally in the country and you apply for affirmative asylum, the
Mhm.
officers they have a long queue of asylum seeker applications. So it might take time for them to give you an interview. It is normal to have like a 5-6 years wait period on your interview.
Mhm.
But in case this person wants a early interview, then there are ways we can help the client to get an early interview. But the normal processing time can be this long.
But he still need a attorney, right?
Yes, definitely, because when he has to appear before the USS officer for the interview, his application needs to be updated because after a few years, things might have changed. He might have moved to a new house. He might have a lot of things might change in these 6 years. So we have to update that. We have to provide more and more proofs because USS officer will make the determination based on the current facts and not on the past application filed 6 years before. They'll see that how over these 6 years this person have been here, and how he can prove that there is a continuous like threat in his country. He cannot go back to his country. So attorneys are required definitely to add on
More.
uh, more legal briefs to his application to strengthen his application. And Zhang goes to a lot of interviews, so Zhang will be the best person to speak more about it.
Please, Mr. Jang.
Yes, thank you. So for asylum, when the client wants to have an earlier interview, there is a way, for example, bring actions against the DHS, can give the client an earlier interview date. But I personally do believe it may hurt the case because if, for example, this month's USCIS officer only allowed to grant certain number of approvals, and then you push your case to the front line, which make you have the interview, but later case referred to the immigration court. On the other hand, I always tell the client, okay, actually you can just take your time here to build your credit. Usually for me, it's like when I attend hearing, if the case here pending in the United States for example 8 to 10 years, usually even the factual information is not as strong, but client has good credit here, good tax record, police clearance report, and good moral character letter support the case, then the client can have a really good outcome. So I always tell the client, when you have immigration status here in the United States, when you have your work permit, actually your asylum case can wait a little bit. I always ask them to patiently wait and work with the USCIS, rather than, for example, we send them like letters require earlier interview. But again, like if client has an emergency situation, like a family member may need urgent care, in those type of cases, when we make requests with the USCIS, if they see, okay, client seriously need to have interview earlier, the family member is in critical health condition, then it may happen like an earlier interview date may be granted to the client, and that enables the client to have the asylum status sooner. So client has like more confidence to travel abroad. Yes. Thank you.
Thank you so much, Mr. Chang. The last question for today about the filling appeal before immigration court. सो कैन न्यू एविडेंस जो हम अपील है वो अपील के बाद हम लोग फाइलिंग कर रहे हैं, अपील फाइलिंग कर रहे हैं, तो उसमें कोई नया एविडेंस हम लोग डाल सकते हैं कि नहीं? कैन न्यू एविडेंस बी सबमिटेड व्हेन अपीलिंग ए केस टू बोर्ड इमिग्रेशन अपील्स?
Usually not, because when these appeals are filed, basically you are trying to say, based on the current evidence, there was an error made by the immigration officer or the immigration judge, and you want the supervisory immigration judge to review that. But in case there is a evidence that is generated, like after, but that change the outcome of the case, and वो evidence आप उस टाइम ऑब्टेन नहीं कर सकते थे किसी भी रीजन से, आपको वो एविडेंस तब नहीं मिल पाया, तो वो एविडेंस जरूर आप वापस बोर्ड ऑफ इमिग्रेशन जज के सामने प्रेजेंट कर सकते हैं.
You mean
एंड दैट
he or she, anyone appealing the file, they have to be proof of why they make new evidence, right?
यस यस.
उनको
सो
बताना होगा कि ये क्यों
बेसिकली
मतलब नया
नया
एविडेंस लेके आए.
एविडेंस, या बेसिकली कंप्लीटली नया एविडेंस अलाउड नहीं है, बट कोई ऐसा एविडेंस जो आपके केस में एक रीजनेबल टाइम पे आप नहीं लेके आ पाए थे और उसकी वजह से आपका केस डिनाई हुआ, और वो एविडेंस आपको बाद में मिल गया जब आप अपील कर रहे थे, तो वो एविडेंस आप प्रेजेंट कर सकते हैं,
You
बिकॉज
mean
दैट एविडेंस
with the
कैन चेंज.
solid reason?
या, so that is possible, yes.
Yeah.
And
Thank
Zhang
you.
can tell more if yes,
Can
Zhang, you
and
can add
please
more.
can we submit the new
Yes,
evidence?
yes. Yes, so again, when the case is when client appeals their case with the BIA, for like for example, if client does not agree like the judge's discretionary findings, we can do that. But at the same time, like the evidence record is actually sealed, so the rule is before the final decision and if client could have obtained evidence, then like it has to be like submitted back then. So motion to reopen does not consider the evidence which could have submitted before the final decision issued to the client. But at the same time, like when we do appeal cases, if we visit the declaration, sees okay, it's not very well drafted, or per the back then like standard, well, like a detailed declaration may make client like look less credible. We actually will submit a new declaration along with the appeal. So even the judge like should not consider that. But some judges really okay, what happened to the client? I want to take a close eye on the case, and maybe I just look at the new declaration and to see what truly happened to the client, and that happens. So again, like my practice is conservative, but at the same time liberal, because like I still remember in my evidence class, like the professor say something like, okay, when the juror hears something, even objection overruled, but the juror heard it, like at the same time, like same thing here. If the judge sees the new declaration, even the judge should not have considered it as part of evidence, but nevertheless it supports client's case. So again, like when we do our cases, we not just adhere to the strict rule and standard, we always try our best to see okay how far we can push, and what is the best for the client. Thank you.
Thank you so much, Mr. Chang. Thank you, Ms. Kanika. You guys did very good job. I think everyone understand and you guys have explained very well. So आज का प्रोग्राम तो यहीं खत्म होगा. I am repeating again कि ये प्रोग्राम हमने बगैर नोटिस के आप दिया. So next प्रोग्राम हम आपको कल I mean मंडे ट्यूसडे तक नोटिस करेंगे कि हम किसी विषय पे किस सब्जेक्ट पे बात करने के लिए आ रहे हैं. I know this time is most of the people need the immigration help. Again repeating, आप लोग को बहुत सारे सवाल होते हैं, तो आप सारे सवाल अपने जैसे अभी किसी ने मेरे को भेजा था क्वेश्चन, व्हाट्सअप किया उन्होंने कि आप ये पूछ देंगे, तो आप भी इसी तरह से व्हाट्सअप कर सकते हैं. ड्यूरिंग द लाइव आप पूछ सकते हैं, ड्यूरिंग द कमेंट करके आप पूछ सकते हैं. लाइव के दौरान आप कोई भी आपको क्वेश्चन है तो प्लीज जरूर पूछे. आपको फ्री ऑफ कॉस्ट वेरी वेल एक्सप्लेन कर रहे हैं. आई डोंट थिंक एनीवन कैन एक्सप्लेन मच बेटर देन these people. They both are you guys very nice job. So please पूछें. और दूसरी बात ये, this is very informative program. तो आप लोग प्लीज शेयर भी जरूर करें, ताकि अगर मान लो मुझे जरूरत नहीं है तो मेरे किसी दोस्त को जरूरत हो सकती है, कुछ पूछना चाह सकता है, तो उसको उसके सवालों का जवाब मिल जाते हैं। तो प्लीज हेल्प ईच अदर, बिकॉज everybody know I don't want to be say the words, but everybody like suffering with a lot of things this time since 2 months. So most of the people, like 80% people, have the immigration questions about the spouse visa, the e-visa, the work permit. So you guys can ask, and I think most of we done today. And I got the more a lot of information. I didn't know to some kind of things. You guys explained. I didn't know to, but I asked you. I got my answer too. And thank you so much, Mr. Jang, Mr. Miss Kanika, and Mr. Naresh Gehi. Thank you so much. You provide these two senior people. I mean, very experienced people to talk about the immigration help. So, Mr. Again repeating, Mr. Naresh Gehi, जिनको asylum के cases का किंग कहा जाता है, इनकी लॉ फर्म जो है, इनके तीन है ना आपके लोकेशन क्यू गार्डन?
Yes. न्यूयॉर्क में 3 है और एक टेक्सास में है मैम।
न्यूयॉर्क में एक बार आप दोबारा रिपीट कर दो, वी विल गिव them to you.
New York, we have 3 locations. One is at Ozone Park, where we both are. Then the second is at Jamaica, and third is in Jackson Heights.
जैक्सन हाइट। सो 3 आपके पास है, आप लोग डायरेक्टली जाएं, फोन कॉल करके अपॉइंटमेंट लें, जो भी आपको जैसे भी आपको सहूलत लगे, आपको फुली हेल्प मिलेगी और बेहतर तरीके से मिलेंगी। एक बार जरूर जाएं और आजमाएं कि कितना फर्क है मिस्टर नरेश गे की फर्म में और दूसरे अटर्नी की फर्म में। सो आज का प्रोग्राम हम
Also like to tell the contact number and our website details so people can visit there and book a free consultation with
Yes,
us.
sure. I will mention in the after the program we will post, we will mention, but you can tell right now if you want it.
Yes. The contact number is 718-577-0711 and the website details are www.gehilaw.com. Thank you and please book your consultation today.
Thank you so much. I will post this all information and contact information with the after this show, so you guys can contact them. And thank you so much for watching Preetnama, and keep watching this whole month. This was the first show. Next and next week, I mean 4 show for immigration continuously. If you have questions, just write on the paper and ask on us. So thank you so much, everyone. Thank you for keep watching Preetnama. Thank you. Thank you, guys. Thank you, everyone. Thank you, Mr. Jang.
Thank you.
Kanika.
ਲੇਟੈਸਟ ਨਿਊਜ਼ ਸਭ ਤੋਂ ਪਹਿਲਾਂ ਆਪਣੇ ਫੋਨ ਤੇ ਦੇਖਣ ਲਈ ਸਾਡਾ ਚੈਨਲ ਸਬਸਕ੍ਰਾਈਬ ਕਰੋ ਅਤੇ ਨੋਟੀਫਿਕੇਸ਼ਨ ਲਈ ਬੈਲ ਆਈਕਨ ਜ਼ਰੂਰ ਦਬਾਓ।